thanks to everyone for joining us today. Our broadcast will last about 45 minutes. Even companies with the best managed post-write-off portfolios are discovering that it's becoming more expensive to recover bankruptcy debt. And the additional regulatory and legal requirements are at the top of the list of causes. But in addition to the increased costs, the recent changes in claim filing requirements and interpretations of case law are also introducing new risks for lenders and debt owners. Here today to brief you on these changes, including an update on Crawford and the latest on the Supreme Court, is Lawrence Friedman, Managing Partner of Friedman Partners. Mr. Friedman is the immediate former director of the U.S. Trustee Program for the Justice Department and a former managing director at Bear Stearns. Currently, he handles bankruptcy cases and is a respected expert in managing distressed debt portfolios. And with that, I will hand it over to Lawrence. Welcome, and thanks for being with us today.
Well, Donna, thank you so much for having me and for giving me the opportunity to bring the people in this webinar up to speed on a couple of areas that really have been changing dramatically over the past few months. And so if we can have the next slide, let's dive into it. What I'd like to talk about today are really two areas. One has to do with the creation of proofs of claim, the two different processes that are available, one which most servicers have been using, and one which is probably the new preferred method. And then I'd also like to talk about stale debt. Stale debt became a big issue with the Crawford decision back a couple of years ago out of the 11th Circuit, a Florida case. It has been trudging along through the circuits around the United States with mixed results, and it is particularly interesting now because the U.S. Trustee Program has weighed in with an enforcement initiative. So a lot going on in this area, and I'd like to cover that now. So if we can have the next slide, we'll dive into this. The creation of a proof of claim form, begins with the form itself. The forms are put together by the Federal Rules on Bankruptcy Procedure. The form that was used up until December of last year, this form B10, the second page deals with the attestation of the person filing the proof of claim. So let's take a look at that. You notice that it says a couple of things here. One, who are you? I'm the creditor, I'm the creditor's agent, etc. Check the box. And then it just has a pretty simple sentence. I declare under penalty of perjury that the information provided in this claim is true and correct to the best of my knowledge, information, and reasonable belief. Now that pretty much covered it under the way most servicers and others who filed claims in bankruptcy, including, for example, the IRS, prepared their proof of claim forms. A lot of those proof of claim forms were filed using batch filing processes. We'll talk more about that, but basically where you validate the information on the front end without necessarily looking at each individual proof of claim form. But still, provided the signer of this form, the B10 form, with a reasonable belief, because if the person signing the form was familiar with the data validation processes, in many cases, servicers were using people who worked on the data verification processes, so they had no problem, were perfectly comfortable, and created no issue by attaching their ECF credentials, the electronic signature, when they logged in to file these proofs of claim. Let's take a look at the new form. You notice the new form appears to have the same information. At the top, it asks for, I'm the creditor, I'm the authorized agent, who am I? And then has three sentences here, which would be the attestation. First, it says, look, I'm authorized to file this proof of claim form, and I'm acknowledging that if there are any calculations on this proof of claim form, including payments that have been made by the debtor, I've looked at those and they have been credited, and thus the claim amount is accurate. That's what that is really saying. And then it says, I've examined the information in this proof of claim. Notice proof of claim is italicized, and have a reasonable belief that the information is true and correct. So still a reasonable belief, but it seems to imply that you've actually looked at the form in its completed fashion. And I'm certain that that's what the Rules Committee was trying to do. As some of these matters are being litigated, we'll know more about it, but for the time being, it appears that the change the Rules Committee wanted, and what they're looking for is the difference between saying the information is correct and one saying that the information as placed on the proof of claim form and in this format is correct. And then adds the sentence, I declare under penalty of perjury that the foregoing is true and correct. Kind of like an added oomph, a little more strength to it. Again, I believe designed to slow people down a little bit, ask questions about the processes, and ensure that they're doing it properly. It's a pretty big change. We haven't had anything like this in probably the past 25 years. So definitely noteworthy, and we'll see how it's impacted as we get in to the enforcement area of this webinar. All right, if we could have the next slide, please. So let's talk a little bit about batch processing. Any good discussion starts with a definition, right? Batch processing is the non-continuous processing of data, instructions, or materials. Batch processing is used for very large files or where there's a fast response time that's not critical. The overriding question that servicers are dealing with is this. Are we talking about a legal process of creating legal documents and filing them in the court? Or is this a business process that merely results in a piece of paper being created, this proof of claim, to file in a legal context? And I must say that, including, I started practicing as a trustee back in 1990, handled more than 10,000 bankruptcy cases. I would have sworn up until this year that there's no question in my mind. Businesses are the ones that hold these claims. They create proof of claim forms. They happen to file them in a case that is within a legal structure, but it's a business process. I would say that the emphasis now, particularly from the enforcement side, is that while this may be a business process, you are filing a document in a federal judicial court, federal judicial process, and as a result, all of the principles that guide the filing of papers that generally bind only attorneys is the principle now that is preferred both by the enforcement agencies and by the courts. So that's really what we're talking about here. Let's move on to the next slide. So let's look at the way this has been done for as long as I've been both as a trustee and overseeing processes at some of the largest filers. The accounts are loaded into a machine, basically a computer file. You load the bankruptcy cases into a file. You have a process where those cases, the accounts that the client has, the bankruptcy cases are matched together. You get a report on that. You validate the data. You put all of that into an electronic machine that generates the proof of claim form. Those are oftentimes put into a container. They can be sorted. You can review them. A lot of times they're tested by sampling, and then once the container is deemed accurate, it is put into the bankruptcy process, the ECF system, by filing them using a batch filing. One person logs in, uploads 500, 1,000, 5,000, 10,000 claim forms, and thus you're off and running. All right, next slide, please. So ideally, the way you'd want to do that is to take the client data, to scrub it, to make sure that it's accurate. These are real bankruptcies. There aren't prior discharges, a whole slew of things that ought to go into the system. You'd go out to the bankruptcy court. You'd collect the data directly from the bankruptcy court. You'd mesh all of that together. And then you would have a paralegal reviewing each case, reviewing the POCs, then taking all of that data, putting it into the filing engine, and letting the filing engine file the POCs such that the person making the attestation has actually looked at each and every case and has actually looked at each and every claim form. So it still could be a batch filing process, but it would need to have these additional things before I would call it compliant under the current standards. Great. Next slide, please. If there are any questions about these filing processes and the distinctions between them, I'm happy to answer them. If not, I'll move into the stale debt issue. If I could have the next slide then. So I know that probably most of the people here, if you've had any touch at all with regard to bankruptcy claims and statute of limitations, you have heard of Crawford. Crawford was a case out of the 11th Circuit, and it's worth reviewing to set up this discussion properly. So in 2001, LVNV, who's a debt buyer, purchased some accounts from a furniture company, happened to be Highland Myers. The debtor's account was included in this purchase, and the account had been charged off a couple of years earlier in 1999. That account sat with the debt buyer until February of 2008. In February, the debtor filed a Chapter 13 petition. And a few months later, pursuant to normal processes and a directive that comes with the notice of the filing, which says if you have a proof of a claim against the debtor, you should file it. LVNV did that. They filed a proof of claim through their servicer, which is known as Resurgent. And then a little kind of wrinkle here, LVNV then sold the theoretically performing proof of claim to PRA. It's worth noting because I don't want people confused about why PRA is in there, but irrelevant as to the logic that follows in the decision. A couple of years later, this is 4 years after the proof of claim was filed, 4 years after the proof of claim was filed, the debtor filed an adversary complaint, basically a lawsuit within the bankruptcy court, against LVNV, Resurgent, and PRA, saying, y'all violated my rights with regard to consumer protection. And basically saying, when you filed this proof of claim, that was really not a proof of claim. It was an attempt to collect a debt through the judicial process. The law is clear that you can't do that, and you should pay me damages. Now, seems bizarre, right? The creditor got a notice from the court saying the debtor filed bankruptcy. The notice said if you think you have a claim against the debtor, you should file it. The creditor did exactly what the notice said to do, using precisely the form provided by the process, and ends up in this lawsuit. Almost anybody would figure this was nonsense, and had you come to me prior to Crawford and I were representing you, I would say, this is a piece of cake. This case goes away on summary disposition. And sure enough, both the bankruptcy court and the district court, which actually happened to draw the chief judge of the district court, dismissed the adversary. They did it under, I think, two different rules, one being, summary judgment on the pleadings, the other being a Rule 56 motion, which is summary judgment kind of after discovery, so once you've had a vetting of all the facts. But either way, both courts, the bankruptcy court and the district court, concluded this is ridiculous. And then the case was appealed to the 11th Circuit Court of Appeals. So let's take a look at what they said in the next slide, please. What the 11th Circuit said was, hang on just a second. Consumer protection law prohibits debt collectors from using false, deceptive, or misleading practices to collect a debt. Further, collectors may not use unfair or unconscionable debts. And where they're headed with this is, had this not been a bankruptcy court, it's almost universally accepted that you cannot sue a debtor for a debt which they may be able to defend because the statute of limitations has run in any civil court. And the reason for that is because consumer protection statutes assume that the debtor is the least sophisticated consumer, and they apply a standard, actually known as the least sophisticated consumer standard. Basically, you're saying, look, you have to assume that debtors are of the lowest common denominator of all debtors, so they may or may not be educated, they may or may not have graduated from high school. They may or may not know what their rights are, and we're not going to subject them to judgments that are taken against them by creditors who know that the debtor may have a defense. That has never been extrapolated over to the bankruptcy system, though, and it's that principle that the debtors and plaintiff bar have been trying to bring into the bankruptcy context. So the court said you use the least sophisticated consumer standard. Consumer protection laws are not made for experts but for the public. All of this is to preserve a quotient of reasonableness. And the court said specifically a debt collector's knowledge and intent, i.e. knowing that the debt is stale and could be subject to a defense, is relevant. Now, you can avoid liability if you can show that you didn't mean to file this proof of claim, but when you are filing these proofs of claim knowing that they may be subject to a defense, you could be exposed to liability. Next slide, please. So how did the court get to this decision? First, they looked at, is filing and trying to enforce a claim known to be time-barred unfair, unconscionable, deceptive, or misleading to the least sophisticated consumer? And what the 11th Circuit said is that, as I said earlier, that we all agree that if you do this in a civil court, this violates the FDCPA. But in a bankruptcy case, the debtor has some protections. The debtor has the trustee to protect the debtor. The trustee can object to proof of claims. The debtor can object to the proof of claims. The debtor is represented by counsel. They can object to proof of claims. And, of course, there's a court and a bankruptcy judge overseeing this entire process. But one of the facts that was of significance to the 11th Circuit was that the debtor raised the idea that the only motivation behind the practice of LVNV in filing these claims was because they know, LVNV know, that the bankruptcy process allows any proof of claim filed to be paid unless it's objected to by the debtor or the trustee. And that really LVNV was kind of playing a game to see whether or not, if they file thousands of these, how many can they get past the debtors or the trustees? And the 11th Circuit imposed liability. Now, to give you a little contrast to that, the 7th Circuit out of Illinois is an Indiana case, I believe, but the 7th Circuit recently took a contrary opinion. And what they said is, look, these kinds of suits should fail. They should fail because the Bankruptcy Code provides a scheme that anticipates that stale debts could be filed. The court endorsed the claims resolution process in bankruptcy, which is under Section 506 of the Bankruptcy Code, and said, we have a process, and this consumer protection stuff has no place in the bankruptcy court. However, the dissent in that case was filed by the Chief Judge of the 7th Circuit, very well-respected judge, could easily end up on the Supreme Court. And what she says is, well, hang on a minute. When you have a large number of claims that you know are stale and you file them, they're not filed for a proper purpose. You don't have evidentiary support for those claims. They're not filed in good faith. And therefore, they violate Rule 9011, which is the sanction rule within bankruptcy. These are papers filed in a bankruptcy case, a federal court, and they should be held to the same standard as any attorney signing any pleading. You didn't file them for the purposes that you say you did, and therefore there should be liability. That was the dissenting view, but by a very well-respected judge, and to tell you why, as this case proceeds, we could have a real split decision. Next slide. So, as this case proceeds on, ultimately to the Supreme Court, right, what do we really have as the setup here? You have a bankruptcy statute where the debtor petitions for relief, lists their creditors. Creditors are asked to file claims. The trustee and the debtor could object, and the claims either allowed or disallowed, versus this consumer protection statute, which is supposed to protect least sophisticated consumers. It's supposed to protect against creditors misrepresenting the status of their debts, i.e. that they're collectible using the court process, and which protects debtors specifically from suing a debtor on a time-barred debt, clearly sanctionable outside of the bankruptcy code. All right, next slide, please. So the court concluded by saying this. They disagreed that a POC is not a collection activity. They said when you file a POC, that's not just notification to the bankruptcy estate. That's actually an attempt to collect the debt. They said that the FDCPA doesn't define terms such as collection of debt or attempts to collect the debt, and that's why it fits within the FDCPA. The court relied on the Supreme Court definition of what collection of a debt is. And the court dismissed the argument that if the POC violated the FDCPA in its attempt to collect the debt, that has to be inconsistent with the automatic stay provisions of the bankruptcy code. So since there's the automatic stay that occurs at the beginning of every bankruptcy court case, and then the case statute anticipates that people will be filing proofs of claim, those proofs of claim can't be characterized as an attempt to collect the debt because we know that there is a stay against people attempting to collect the debt against the debtor. So it's completely inconsistent. The 11th Circuit said, nonsense. We can get right past that. And they declined to weigh in on the specific issue about, well, doesn't the bankruptcy code, which was passed, the most recent version, after April of 2005, the FDCPA from, I think, the late 80s, early 90s, therefore the bankruptcy code, when the Congress passed it, must have considered the fact that the FDCPA was out there and the intent was to preempt the FDCPA. Now, just a footnote here, but it's very interesting why you need to have real subject matter experts on your side, both as servicers in-house and when you seek outside opinions. There's a one-year statute on the FDCPA. You notice that the proof of claim, if you recall, was filed in 2008 and the lawsuit was filed in 2012, 4 years. It's interesting to me that LVNB never raised the one-year statute of limitations. So ironic, a defense that they had to this Crawford case, which was about them violating the statute of limitations. But it's just an interesting side note. It really has no relevance to going forward here. All right, next slide, please. And so what does this set up? It sets up a supreme battle. And sure enough, the Supreme Court has agreed in the term starting in October to accept a case that arises out of these Crawford-type decisions. It is a case out of the 11th Circuit. It involves, I think, Midland funding, which would be Encore Capital. Don't quote me on that. I believe that's what the case is. And what we have is the 4th, the 7th, the 8th, the 9th Circuits, all of which found that these claims fail. The 2nd Circuit, which has agreed with the 11th Circuit, which says nonsense, these claims are viable. And what the Supreme Court has agreed to decide, because they always certify the questions that they're agreeing on, is whether or not the filing of an accurate proof of claim for an unextinguished time-barred debt in a bankruptcy proceeding violates the FDCPA. And number 2, whether the bankruptcy code which governs the filing of proofs of claim precludes application of the FDCPA to the filing of an otherwise accurate proof of claim for an unextinguished but time-barred debt. So the Supremes will be involved. Now, servicers in bankruptcy and people filing proofs of claim in bankruptcy have adapted pretty well to this chaos, primarily, I think, by not filing claims that may be well past the statute of limitations. But now, on this issue and on the claim filing issue that we were talking about with regards to the processing of proofs of claim, the U.S. trustee has begun an initiative, and so that is well worth our time to study. Next slide, please. What the U.S. trustee is currently engaged in is targeting creditors and third-party processors of proofs of claim. And they have these two concerns. One, is the individual who signed the proof of claim the person who actually reviewed the proof of claim? And the program, mind you, didn't start this by having a rule process, putting it out for comment and all these things. The rules, the U.S. trustee program's position is that this was always the rule. It always was a legal pleading. Everybody should have known that. And so when they target this, they're looking backward, retroactively, at proofs of claim that were filed. So if you've been doing it this way for 10 years, their position is you've been doing it wrong for 10 years, and they're inclined to enforce that against you going back quite some time. And then secondly, if you're filing a proof of claim where the statute of limitations has run, you could not have possibly filed that for a proper purpose, because when people object to those proofs of claim, you generally withdraw them. And if they object a lot, you don't file them anymore where they object a lot. So really your purpose in filing these proofs of claim, Mr. Creditor, was to take advantage of this loophole in the law which says that these claims are allowed unless they're objected to, and your game is really a game just trying to see how many of them get past the system without being objected to. You buy them at a significant discount, you leverage that to a significant return, and that is an improper practice as a business practice. The relief that they're seeking on the batch filed claims includes having you withdraw the batch filed claims, go back and review them all, certify that they're accurate, and pay a penalty. In the cases that are pending right now, these are public cases. You can find them if you search PACER against LVNV and Resurgent. There are documents to show that the program, just on the batch filing process alone, was seeking an $18 million penalty, plus this manual review of the proofs of claim. And then secondly, if you filed claims on stale debt that you knew should not have been filed, you should withdraw those PSEs, you should disgorge all the funds that you collected, and you should pay a penalty for that as well. So the damage that can be done is significant. And most importantly for the people on this webinar, the U.S. trustee program in going after Resurgent actually sued their client that owned the proof of claim, the account that they filed the proof of claim for. So their theory is not only are we going to mess with you, but we're going to mess with your clients because your clients should have known better than hiring you to do this process and condoning it. And so we're going to hold everyone accountable. That's something that should scare everybody. All right. Next slide, please. So what are the takeaways? Be sure that your POC filing, processing, and filing practices are compliant and appropriate. If you work with a third-party servicer, make sure that you select one that has processes that have been designed and tested by a subject matter bankruptcy expert. Be sure that your third-party processor has a solid record, stands behind their processes. And of course, pay attention because there's a Supreme Court decision coming, and I'm sure that that will give us some guidance in these areas. Okay, next slide. So that concludes my part of the presentation here, and I'm happy to take questions.
All right, thanks, Lawrence. Let me jump in real quickly first. That is a lot of great information, but before we get to the Q&A, we'd like to take just a few minutes to brief you on WAYPOINT'S approach to bankruptcy debt collection. DANEN SHIEK is WAYPOINT'S SVP of Sales, and he's a 25-year industry veteran, including late-stage debt collection. And he has consulted leading Fortune 1000 companies on their bankruptcy portfolio processes. So with that, I'd like to give DANEN just a couple minutes to chat with you guys, and then we can get back to the Q&A.
Hello, everyone. This is DANEN. As I listen to Larry, and I've listened to Larry for many years, I get this feeling that you might be thinking, so what, now what? And I wanted to jump in just for a second and say, there's probably someone back at Encore Midland who in 2008 wishes that somebody would have come to them and said, hey, you know, the court may have a concern over your process. They were filing lawsuits against consumers who had mortgages who happened to be in their portfolio. The court found over time that Midland was using attorneys who were filing as many as 100 claims an hour or 100 lawsuits an hour, which ended up becoming liens on the consumer's property. When the court looked at it, I said, how in the world could an attorney review 100 lawsuits in an hour, 30 pages, 50 pages apiece, and effectively sign off on those lawsuits and have that be a meaningful process? And that whole lawsuit boiled down to the court saying it's impossible for us to believe that this is a solid process with the appropriate checks and balances, which resulted in about $43 million lawsuit that Midland had to pay with respect to their legal practices associated with suing consumers over their debts. Now, I assume somebody at Encore would have loved a session like this where Larry comes on the line and says, you know, the court's about to look at that process, and the conclusion could very well be that they don't believe that a human being could look at 100 lawsuits in an hour and decide that they're valid. What we're saying here is there's a lot of great companies that do batch filing services for POCs that file large numbers of claims, millions a year. Wonderful companies, wonderful people. That process may be under scrutiny right now. What Larry's saying is, hey, you know what? This looks like those folks may have a problem, and that solution may not be the most compliant in the industry right now. Thankfully for us, our system's a little bit behind times. We don't electronically file without having a claim reviewed by a person. We review the claim before it's filed with the court. We're going to continue to do that. We offer that solution, and although we're not a bankruptcy company, what we've done today is reached out to friends and family. Folks on this call or who have been invited to this call are people that we're currently talking to about many of our services. We thought it would be to their benefit if we brought up an issue that we think is pending in the courts, more informational. We're here to help you with your bankruptcy servicing, but really what we want to do is always be a good partner with respect to compliance. So this is one opportunity for us to bring to your attention there may be something on the horizon here with batch filing and bankruptcy servicing. So the limited number of people, we didn't send this webinar out to 1,000 people, we didn't publish in a magazine. It's not on our website. It's just friends and family that we're talking about other projects with who are saying, hey, this could be a problem. We can help you. We're not a bankruptcy company per se, but we certainly have bankruptcy as a service that we can provide you if you see this as an opportunity or a risk. So that was the point of the webinar. Obviously, out-of-stat claims, which is elevated here and Larry speaks about quite a bit, it's already tested to the point where there's $150 million plus already been fined out there for out-of-stat procedures. So hopefully you've already decided that you're not going to be working that out-of-stat population, and this should really just be a reminder. So anyway, we feel really good. We have bankruptcy experts on staff. In fact, we have Larry as a partner in the process, compliance-focused, and we are specializing in automotive, utilities, healthcare, cable, telecom. So if you need help with that work, we're here for you.
All right. Well, thanks, DANEN, and thanks, Lawrence. Again, a lot of good information. So let's go ahead and move on to the Q&A. If you've got a question, use the Q&A box at the lower right of your screen to submit it, and we'll answer the questions in the order that we receive them. So let me check here for a second. All right, Larry, here's the first question. I realize the B410 form is only about a year old, but are there any indications as to its effectiveness? Is it doing what the government intended, or could there be more changes in the future?
Because it's only been in effect for about 10 months, we don't know what the impact is. We do know that something changed, and we do know that something appears to be that the Rules Committee is looking for individual review. I don't know how many servicers have changed their process as a result of the new form, but I know that the most compliant way, given this new form and what I understand the Rules Committee's motivation being, is to individually review the proof of claim form and be comfortable that the person who's submitting the proof of claim form using the ECF system has looked at it and acknowledges that they've looked at it by attaching their signature to it.
Okay. The next question. My company's been on the fence about bankruptcy debt for a while. With these continuing changes in the regulations and case law interpretation, is there a point where the legal risk just simply outweighs the benefits?
It's a great question. There's a simple way currently to act and be compliant, and that's to do the following, which I think is perfectly legitimate and I would defend personally. Number one, don't file proofs of claim if you know the debt may be subject to a statute of limitations defense. Kind of the corollary to that is make sure that you have a data set that's good with regard to the data about the account that you're going to file the proof of claim in. Because ultimately you're going to have to defend what you did. And if you say, we didn't have the data, but the account was 20 years old, I mean, how much data do you need, right? So that's number one. And then number two is make sure that the process that is being used to file proofs of claim that are enforceable against the debtor and that are not known to have any defenses is compliant. Compliant in the sense that an individual is looking at the proof of claim form. So with those two caveats, sure, filing proofs of claim is not only a good idea, I mean, it's kind of required. If you're not filing proof of claim, other creditors are, and other creditors are getting a larger piece of the pie because you didn't pick up your piece of the pie. So it's important, A, to have your claim adjudicated, and B, to ensure that you get the value that's there for you to get and that other creditors are going to get if you don't file a proof of claim.
Okay. Let's see. The next couple of questions kind of, I think, go together, so I'll ask them both at the same time and just kind of let you answer them in line. The hands-on approach to filing that you outlined seems expensive and slow, so can you walk through a little bit more about what the hybrid approach entails? And then kind of as a follow-on to that is one of the arguments that's been made over time is that a machine is more accurate than a person. So is there a point where this argument of a machine being more accurate than a person becomes no longer valid?
Yeah, I love the second part of that question because I've actually made that argument in representing clients before the U.S. Trustee Program's current initiative. Believe it or not, the government seems unimpressed with the fact that automated processes are more accurate than human processes and seems stuck on this legal context with regard to filing documents in federal bankruptcy cases. You'd think that they would recognize the efficiencies and accuracy of automation, but not to be the case at this current time. With regard to the cost, it shouldn't be any more expensive, and I don't know, you can talk to DANEN, but I would expect it's not any more expensive to have a fully compliant process. And that is because you can still use high-speed processing to get certain things done. It's just that you need to have somebody looking at each individual proof of claim form. Once the proof of claim form is generated, and the process that I've seen that I do agree is compliant, you have basically two screens in front of you. The claim forms are coming up, flash up, flash up, flash up, flash up. You tap a button to go to the next one. You're looking at the account information on the left side, the completed proof of claim form on the right side. You're checking just 4 or 5 data elements that are important to be compliant, and then clicking through the next one. And the few seconds that takes really does not add a significant amount of cost to the filing of the proof of claim form, or it shouldn't. And so I'll stand with that.
Okay. And I think we've got time for about one more question. So again, after this question, if you did submit another question and we're unable to get to it, we'll forward it on to Lawrence and DANEN for follow-up, or you can reach out to them directly using the information on the screen. So the last question. Do you think the FDCPA definitions will be tightened in an attempt to bring more influence to bear on bankruptcy debt collection?
I don't know what you mean tightened. Will Congress revisit the FDCPA? More likely the courts are going to draw some lines around these cases. But there is going to be some clarity coming because what you have now is chaos amongst the circuits. You're dealing with a uniform federal statute. It should be applied uniformly, both these statutes. And so, clarity is needed, and the way you get that generally is through litigation up to the Supreme Court. So I think that's kind of what the future portrays.
Okay. Well, that wraps up our time today. Again, if you did submit a question and we were unable to get to it, we will either have DANEN or Larry follow up with you. Or, again, we've got their contact information up on the screen there. Please feel free to reach out to them directly. And with that, we thank you again and look forward to having you on a future broadcast. Good afternoon.
Thanks, Larry.
Thank you.